torts enthusiasts, welcome back to Practice Perfect. In this review, we will learn about negligent infliction of emotional distress, a claim that under certain circumstances may be brought when an actor's negligence causes serious emotional harm to another. While negligent and intentional infliction of emotional distress claims are similar, they are in fact distinct torts. The salient difference relates to the degree of fault a plaintiff must prove to prevail on the cause of action. Intentional infliction of emotional distress, covered in a separate Practice Perfect review, redresses intentionally or recklessly caused emotional distress, whereas negligent infliction redresses emotional distress caused by ordinary negligence. Early on, courts rejected claims based purely on emotional damage. They did so because, unlike physical harm, which can more readily be observed, verified, and monetized, emotional distress is internal to the plaintiff, harder to quantify, and possible to fabricate or exaggerate. Moreover, courts feared that the number of such claims would overwhelm the court system and result in a rather sizable shift in how such costs are insured and spread. Yet despite the caution, modern doctrine has evolved to permit emotional distress recovery. In light of these concerns, however, courts carefully control the claims that reach a jury. Also, while the damages for, say, a broken arm are more readily quantified by evidence like doctor's bills and medical receipts than, say, 6 months of emotional trauma, juries can and do quantify emotional damage all the time in cases in which a plaintiff has suffered physical harm. It is important to understand that jurisdictional approaches vary, sometimes a great deal, when it comes to negligent infliction. And given this muddiness, here we endeavor to summarize the basic principles and will generally adopt the third restatement approach. It is useful to divide negligently inflicted emotional distress claims into two types: those in which the defendant's negligence placed the plaintiff in danger of immediate bodily harm, and those in which the plaintiff was not placed in such danger. Beginning with the first type, the third restatement takes the position that the law permits recovery when the defendant's negligence placed the plaintiff in danger of immediate bodily harm and the plaintiff's emotional harm resulted from this danger. This is often referred to as the zone of danger rule, and it evolved as the first major exception to the general rule that a negligent actor is not liable for purely emotional harm. Imagine Jack operates a skydiving company. Because Jack failed to properly secure Jill's parachute, Jill's harness broke in midair. Because Jack was skydiving in tandem with Jill, Jack was able to reaffix Jill's harness and deploy her parachute. While Jill did not get hurt, she thought she would surely die and suffered severe emotional distress. Here, Jill can recover for negligent infliction. Jack was negligent. Jack's negligence placed Jill in danger of an immediate physical impact, and Jill's emotional harm resulted from Jack's negligence. Suppose Mark was walking along a city sidewalk in front of an outdoor restaurant. Mark slid on a puddle of grease the restaurant owner had carelessly left the previous night, and Mark slipped into the busy street right in front of an oncoming bus. The bus's horn blasted, its tires screeched, and Mark saw his life flash before his eyes. The bus came within an inch of hitting Mark, miraculously stopping just before impact. Under the approach of the third restatement, does Mark have a negligent infliction claim against the restaurant owner? Yes. Here, the restaurant owner was negligent. Her negligence placed Mark in danger of an immediate physical impact from the bus, and this caused Mark's emotional harm. One more for you. Suppose Allison was driving down the street when a sudden 150-mile-an-hour wind gust blew a limb from a tree on Bill's property onto the street. Bill is a meticulous homeowner and appropriately maintains his trees and grounds. Allison saw the tree limb coming straight towards her car and braced for impact, but another sudden gust blew the limb away from Allison's car at the last second, narrowly sparing her life. Does Allison have a negligent infliction claim against Bill? No. While Allison was certainly in the zone of danger, here Bill was not negligent and thus not liable for negligent infliction. Let's try another. Imagine Chemco manufactures ditoxin, a known carcinogen. Chemco's failure to properly secure a large ditoxin holding tank led to a sizable release of ditoxin into the soil and groundwater, which also served as the public drinking water supply. Chemco's negligent failure to contain the material meant that hundreds of thousands of individuals ingested or were otherwise exposed to ditoxin. Can the individuals exposed, who fear that they will at some point develop cancer, bring claims? Not likely. Most courts will deny suits based on such fear of future diseases, on the theory that the injury is speculative, and on the policy of avoiding a flood of litigation claims. Some courts do permit them, but typically only do so when the plaintiff can prove she more likely than not will actually contract the disease. In this way, the court permits claims by plaintiffs who will probably suffer physical injury while balancing competing concerns to avoid indeterminate or excessive liability. While courts evolved to permit claims by plaintiffs like Jill who were themselves directly in the zone of danger from the defendant's negligence, they still denied recovery beyond that. Modern courts have since broadened their approach and now permit a second line of recovery in certain specified categories of activities, undertakings, or relationships, even where there was no danger of physical harm. The first such category arose in the context of claims by third parties or bystanders who suffer emotional harm by observing a tort committed upon another person. Imagine Talia and Ursula are crossing the street to get to the school bus stop, and Berenice, their mother, is standing on her porch watching them. A speeding car driven by Jones runs the stop sign and hits Talia, critically injuring her and narrowly missing Ursula. Both Ursula and Berenice are traumatized. Under the traditional zone of danger rule, can they recover for negligent infliction of emotional distress? Ursula can, but Berenice cannot. Ursula was in the foreseeable zone of danger.
What's the size
However,
of that?
Berenice, standing on her porch, was not in danger of immediate bodily harm.
What's the size?
But this traditional policy made little sense and led to unsatisfying results. A mother's anguish at seeing her child negligently injured is surely foreseeable, and there are no strong concerns about her fabricating emotional distress claims.
What's the width?
Yet imagine if an entire crowd of onlookers witnessed and was traumatized by this accident. Should every bystander be entitled to bring a claim? This would open the courts to a flood of litigation, and lines must be drawn somewhere. So many modern courts now also recognize what is known as the bystander rule, permitting recovery by close family members who suffer severe emotional distress by contemporaneously perceiving negligently inflicted physical injury, even if they were not in the zone of physical danger created by the defendant's conduct. Applying the bystander rule, both Ursula and Mom Berenice recover. Note that in jurisdictions that follow the third restatement, Sister Ursula here recovers on two theories: directly, based on her fear that she herself would be injured, and indirectly as a bystander to Talia's injury. Mom Berenice recovers only under the bystander rule. A number of courts began to take an even more expansive approach to bystander recovery, reflected in the case of Dillon versus Legg. In fact, our Ursula, Berenice, and Talia hypothetical is based off the Dillon fact pattern. The court in Dillon adopted a 3-factor foreseeability test to evaluate whether a plaintiff may recover. A court should look at, number 1, whether the plaintiff was located near the scene of the accident rather than far away. Number 2, whether the shock resulted from a direct emotional impact upon the plaintiff from the sensory and contemporaneous observance of the accident rather than learning about it later on. And number 3, whether the plaintiff and the victim were closely related rather than strangers or distantly related individuals. To understand the distinction between the Dillon factors and the third restatement approach, suppose Talia and Ursula's father Howard was in the backyard when the accident happened. He did not see the accident, but he heard it, a sound he will never forget, and he heard his family members screaming. He ran to the scene and saw Talia badly injured on the ground. Under the bystander rule, can Howard recover for negligent infliction? No. Although Dad Howard was a close relative, he did not contemporaneously perceive the event. Under the Dillon factors, can Howard recover for negligent infliction? Quite possibly. On these factors, Howard, a close family member, was located near the accident and close enough to auditorily perceive it. Many jurisdictions have since rejected the more expansive Dillon approach, though it is still used in a small minority of jurisdictions. Suppose Dan owns a funeral home. Because Dan failed to properly identify Ella's mother's body, Dan switched Ella's mother with the body of another individual. During the viewing, Ella was severely emotionally distressed to find another person in her mother's casket. In this situation, the law has carved out another exception to the requirement that the plaintiff be placed in the physical zone of danger. The negligent mishandling of human remains is an activity especially likely to cause serious emotional harm, and most jurisdictions would allow Ella to bring a claim. All courts require significant emotional harm, that is, harm that a reasonable person would suffer. While most courts do not require proof of accompanying physical symptoms like vomiting or headaches, a minority of jurisdictions do require such proof. Finally, note that the question of which activities, undertakings, or relationships support liability for negligent infliction is a question of law for the court. This is because it primarily involves a policy question, and a court will determine whether the plaintiff is owed a duty of care. Some questions might involve questions of fact for a jury to decide. For example, suppose Mork and Mindy have lived together as close friends operating a singular household unit for over 15 years. If Mindy is severely emotionally distressed from watching Mork get run over by a car negligently driven by Jerry, can Mindy recover? The answer depends on how the jurisdiction defines close family member. Some jurisdictions will have specific rules based on consanguinity. In such a situation, Mindy will not be owed a duty. Some jurisdictions have more functional rules, like someone in an intimate, long-standing, and emotionally significant relationship with the injured party. In such a situation, it is for the jury to determine whether Mindy in fact meets that definition. Finally, note that a small number of courts have abandoned these traditional restrictive rules on emotional distress and instead favor analyzing such claims under the general negligence framework, although all courts require that such distress be severe in order for a plaintiff to recover. This concludes our Practice Perfect review of negligent infliction of emotional distress. We recommend you apply